Welcome to the Intellectual Property and Trade Nexus Podcast. I'm the IP and Trade guy, your host, Tom Tombeka. Welcome wherever you are following us, wherever in the world you are, Africa, Europe, the United States, Asia, wherever part of the world you are following, we say welcome to the Intellectual Property and Trade Nexus Podcast. And today's edition, we will be covering a new topic, a new subject matter that is critical to we as a people and culture, irrespective of the nation you come from, irrespective of your nationality, and even being a global citizen. We are looking at this subject that deals with a very critical component of our society as a people, as a community, as a nation, region, and internationally. So the topic today focuses on intellectual property and intangible cultural heritage. IP and intangible cultural heritage. And basically this the the key international organization dealing with intangible cultural heritage has to do with the United Nations Educational, Scientific, and Cultural Organization. So this organization is an international body responsible to institute, to administer, and regulate from the international level, dealing with membership countries that are member of the UN and have expressed interest in domesticating the UNESCO Heritage Treaty domestically. So today's topic is the intellectual property. Intellectual property and intangible cultural heritage. So with all further ado, let's just move straight into the topic for today. So we are going to basically be reviewing cultural heritage from the perspective of intellectual property law. What intellectual property law says about the protection of uh, cultural heritage. What are the provisions available to creators, inventors, innovators engaged in uh, products, services, and the cultivation of new ideas within a framework of cultural heritage? So, regarding the relationship between intellectual property and intangible cultural heritage, is quite a different sort of logical basis or regime as opposed to other international regimes. So that relationship with IP has with intangible cultural heritage is quite different from the relationship between cultural heritage and human rights, cultural heritage and environmental law, cultural heritage and administrative law. So there are quite a different regimes that specifically might target several topics and connections with uh, intangible cultural heritage, but the way intellectual property law protects uh, cultural heritage might quite vary from other provisions and regimes. So, intangible cultural heritage from the perspective of intellectual property law focuses on innovation. innovation in the context of what is the novelty uh, of this intangible cultural heritage, what makes it different, or what makes it something new, something exceptional, something unique to the cultural space in that vein. And another perspective has to do with what specific contribution can be derived from a particular cultural heritage or particular creation or particular invention that falls within the domain of cultural heritage. So these are the perspectives we are looking for. Intangible cultural heritage from the perspective of IP focuses on innovation. Innovation, what is the novelty of that innovation, and what are the specific contributions that can be derived from a particular creation or intangible cultural heritage that no one else has, or which is in some instances we consider as give rise to a monopoly that the creator or the inventor gets to benefit from. So what is the new invention that is being created in the space of cultural heritage, and is this invention novel enough that it can give rise to possibility of being a monopoly which the creator or the inventor of that invention can exploit, whether through financial or material benefits from. So, what are the specific contributions or, or creation and invention can provide to the society in general as it comes to the market or is being produced? So, what is new? What new in intangible cultural heritage for the future? We want to understand what are the new ideas, what are the new regulations, the policies, the regimes that are in, whether from the past to the present or the future. What are the future discussions that they are having? What is what what is being implemented now that came from the past, and what is the present, as well as what are the future discussions for intangible cultural heritage. So the past being the object of protection for intangible cultural heritage. What that means is that most of the treaties, the laws, the regimes we have in place are regimes from the past that provides a specific level of protection for intangible cultural heritage. So the past being the object of protection for intangible cultural heritage implies that the current regime, the current laws, the current policies that are currently in force, whether internationally, regionally, or domestically, are provisions, laws, and policies from the past that are being implemented presently. The past is to be protected given certain considerations in the present for the benefit of our future generations. So that is the coordination. We protect past creations, past innovations, and just to be specific, so my audience can understand, when I talk about creation in intangible cultural heritage, I'm speaking of creations like statues, paintings, uh, natural and cultural heritage sites, museums, and all these innovative spaces and products. So, products and services we are referring to when it comes to intangible cultural heritage has to do with statues, uh, paintings, museums, all these creative products and spaces that project a culture of an identical community, a nation, people, or region. So these are the products that I'm referring to when I speak to intangible cultural heritage products and services. So we say the past is to be protected. All the laws and policies we have in place to protect cultural heritage, giving certain considerations in the present. What are the contemporary realities that we are facing to ensure that all these intangible cultural heritage and assets are protected based on the present realities that are within our given societies, our given nations, regions, and at the international level. And all this is done to ensure that the, the all these steps are taken protecting the past based on the present consideration of the realities we are going through to ensure that the future generation, the future nationalities, the future members of the global society can benefit from these artifacts, the statues, or these cultural heritage and intangible cultural heritage in general. So IP law, intellectual property law, is based on private law. So the legal mechanisms that are in place currently are basically enforced through private law mechanism or private law legal mechanisms like property regimes, contract laws, among other laws, policies, and regulations. That's that simply implies that in order to enforce intellectual property law, you have to use you as an individual, be it a creator, an inventor, or whatsoever innovator, you have to use private firms. You can use the court system as an individual because it's your private right. So you as an individual can ensure wheresoever country, region, or territory that you are legally registered as an inventor, an innovator. You have all your rights and registration, and you falls under a specific jurisdiction. You as a private individual or be a business, you will use lawyers, you will use private law firms, and you will use the courts to defend your right or go against someone that you feel is exploiting your innovation or creation. So private IP law is basically enforced through private law and private law legal mechanism. So, like we spoke of, property regimes, contract law, among other existing existing future of legal regimes available to you as a creator or innovator. Whereas heritage law in practice is protected by public law. So for the two dynamics, IP law to ensure the enforcement and protection of your rights on IP law, you have to use private law. You have to use individual lawyers, you have to use a law firm and the court system, the infrastructure within that respective jurisdiction that you have legal rights and you are covered under the government, the systems that are available to you through private law, you can use that direction. As opposed to heritage law, heritage laws is implemented or through public law. So what that means is that the government then will be the one ensuring that whosoever is violating a specific intangible cultural heritage or cultural asset of that country, that community, the government will be the one to enforce and to defend and protect that specific cultural heritage that is being exploited, whether criminally or whatsoever. So that's the difference. IP law is enforced through private law, and whereas heritage law in practice is protected by public law, although certain aspects may be covered by private law. Certain aspects of heritage law, there are portions and specific portions that will be covered by private law, but in general, heritage law is covered by public law. So we are talking about administrative law. These are laws that are used to ensure the enforcement of heritage law. So we're talking about administrative law, environmental law. Once a country is signed on to the UNESCO treaty, so UNESCO is, like I said initially, is an international organization of the United Nations, responsible for educational, scientific, as well as cultural activities within that international body. So members of the United Nations are primarily member of UNESCO, but they have to express interest being a full-fledged member of UNESCO and sign on to the UNESCO treaty dealing with cultural heritage. And once that is done, then domestically, that country, that member of UNESCO, will have to use administrative law, environmental law, and other laws available to ensure the protection of cultural heritage within their domain, or even cultural heritage outside their domain that have been violated. They can advocate and speak against any illegal and illicit exploitation of those cultural heritage. So this is how the both regime works. Intellectual property ensure the enforcement of creators, inventors, and innovators working in the cultural heritage space through private law, and private law legal mechanisms that are available to them in their specific jurisdiction. While on the other hand, heritage law in practice is a public law, is enforced through public law, although certain aspects of heritage law are enforced through using private law. But in general, heritage law in practice is protected by public law. And this specific public law we are referring to can be administrative law, environmental law. Once a nation signs on to the UNESCO Heritage Treaty, and they are under obligation to domesticate whatsoever international law nationally and to implement said law. So then the nation will be under obligation to make sure that these cultural heritage sites, inventors, and those within that specific domain are protected by law. And UNESCO is the international body responsible to execute all these laws and regulations that have the objective of protecting intangible cultural assets. So moving forward, we also want to highlight that this regime of ensuring the protection of IP within the domain of cultural heritage ensures that in IP law, the creator is ultimately the central figure to the innovation space. And there are varying differences if you are dealing with copyright that invokes the concept of droit d'auteur, which is in French, and in English, which means the right of the author, rights of the comparative law of intellectual property. So, in intellectual property law, the focus and the concentration is placed on the creator, the inventor, the innovator. That is basically the ultimate central figure of the intellectual property law. So in conclusion, IP law regime focuses on the creator, while heritage law focus on the protection of the creation or the invention. And heritage law focuses not on the benefit of the creator, but the benefit of the community, the general public, or in general, globally, humankind. So in IP law, the focus is placed on giving protection for the benefit of the creator, while in heritage law, the focus is placed on the creation, the product itself, be it statue, be it paintings, be it whatsoever objects and products that falls on the heritage law. So heritage law focus is on the creation, while IP law focus is on the creator. And heritage law focus on the creation is to ensure that the public, whether it be a community, the public, or humankind in general, can benefit from whatsoever public statue or natural heritage, cultural heritage, and all these all these objects and products that fall within the regime of intangible cultural heritage. So heritage law protect the creation, the invention, and not for the benefit of the creator or the inventor, but for the general public, whereas IP law focuses more on the economics, like creating a monopoly for the exploitation of the creation financially and materially. So these are the varying interest of the two laws. Intellectual property law concentrates on the inventor, the creator, and the innovator, and ensure that whatsoever incentive can be provided if your invention is novel enough, is unique enough, and that novelty can give rise to monopoly that you as a creator can then exploit that essence of monopoly to financially benefit from your creation, financially and materially benefit from your creation and inventions. Whereas heritage law ensures that it focuses on the processes that leads to the outcome of a creation or an invention and ensures that the general public can benefit from said creation. IP law also focuses on ensuring that the creator economic interests is protected so that he or she can be incentivized to create more, innovate more, and invent more. So IP law concentrates on products like books, music, and other innovations. While on the other hand, in heritage law, the concentration is placed on the processes that allow for access to these creations and inventions and look at the overall performance of your book or your music. You as an inventor, you as a writer, you wrote a book. IP law want to ensure that your book, your rights to your book as an author is protected and that no one can easily violate your law and go scot free. That you have the court system in place through private law to go after anyone infringing on your right as a writer, and that you can be the only one making decisions on who buys your book. You can make a determination on contracts you can have with those book houses and publication areas, and you can accrue the necessary benefit from your creation as a writer. And this will serve as an incentive for you to write more books, given the economic dividends you have accrued from being a writer. So, while on the other hand, heritage law ensures that your book, your music, how are the processes leading to them being accessible by the general public is protected. The processes through which someone interested in buying your book to read your book, or say you have a book on intellectual property and intangible cultural heritage, and someone is interested in buying your book. So the processes that leads to that individual accessing your book, after that individual have accessed your book, read it, and enjoy it, and look at the overall performance of your book, maybe through feedback, through surveys, and what have you. So that is cultural heritage law. Look at the processes that leads to the access of the general public, and as well as the performance of your creation and invention. So the idea of intangible cultural heritage is to protect the entire layers of social as well as the cultural arrangements available for the protection of that region. So the next question we want to ask ourselves is, what is heritage and how it translates in the law? What is heritage and how it translates in the available or existing laws that are enforced? So, firstly, let's look at the UNESCO scheme to understand the stipulated guidelines for intangible cultural heritage. So, within the United Nations Educational and Scientific as well as cultural organization, there is in existence the UNESCO scheme that give stipulated guidelines on what specific what are the specific creations and inventions within the cultural domain that are covered. So basically, there are 5 main domains of heritage, and we are just going to go through the 5 domains of heritage. So the first domain of heritage deals with protecting heritage in war times. There are 5 domains for heritage that is stipulated within the UNESCO scheme. And the first domain deals with protecting heritage in war times. And this domain came through in 1954 through a Hague Convention. So at this convention, the Hague Convention in 1954, they made the decision to protect heritage in wartime. That's just true in case of a crisis, nobody or no faction, army, or whatsoever group, armed group, should go destroying cultural heritage, museums, paintings, statues, artifacts for that matter. So this convention basically highlight or speak against the destruction, the looting, the smuggling, and the use of cultural heritage and artifacts for the use of criminal or personal gains. So you cannot violate, you cannot go helter-skelter destroying cultural heritage within a specific community or nation just because it's war times. So this convention exists under UNESCO to ensure that is enforced. Take for example, during the war in Syria, there were several attacks made by ISIS on museums that were filled with rich artifacts, art and craft, all of very rich cultural access. So the second domain has to do with movable heritage. Movable heritage. So this domain was basically done in 1970 as a means of safeguarding cultural objects within specific jurisdiction, regionally or internationally. So, movable heritage, we're talking about museums, materials, cultural objects within the museums. We're talking about statues. We're talking about paintings. We're talking about zoological and animal specimens. We're talking about stems. We're talking about coins, musical instruments. Basically, any cultural object that can be moved or carried. So, this 1970 convention uh, that was done to ensure the safeguard of cultural objects was meant to ensure that any cultural object that can be moved or carried cannot be destroyed, cannot be stolen, cannot be smuggled, cannot be looted just because someone have the opportunity to do so. So the essence is to ensure the movable heritage of 1970. The essence and the quintessential purpose of this convention is to ensure the curbing of illicit trafficking, the curbing of illicit traffic in cultural objects, to ensure that illicit trafficking of cultural objects are curbed, if not eliminated. Then we move to the third domain. The third domain has to do with the World Heritage Convention of 1972. And the World Heritage Convention of 1972, the has two categories: the cultural or natural category and the mixed sites category. So the mixed sites category speak to the 121 sites that is on the World Heritage List. All these sites were investigated, were sorted out, and selected to be the global cultural sites around the world that have been recognized on the World Heritage List by UNESCO. So a mixed site is what we refer to as a natural site that has been modified by human actions. So this site, initially it was a natural site, and site in this vein mean a site could be like the well-known site of Mount Kilimanjaro in Tanzania. So that's a natural site. It's not man-made, it's natural. So that is why we're referring to as a site. So take for example, Kilimanjaro was a natural site and is a natural site. But for this hypothetical example, it was a natural site. People went there and made some changes to the site. So then we will now refer to that site as what? Mixed site. Because the natural site was not was then modified by human actions. But Kilimanjaro remains a natural site for now, just using a hypothetical example that should in case if what Kilimanjaro is now presently. Men or people went there, and irrespective of people climbed in a mountain, but they did a lot of activities there that modify the site and change it significantly. Then that will not be a natural site again, will be now a mixed site that may have a natural component as well as a man-made component. That's what we refer to as mixed site. So these sites, Italy is well known to have the Mellini Tower, the Florence site. So Italy is well known. Italy has 55 of these World Heritage Sites. And Italy ties with China that also have 55 in number of World Heritage Sites. And so Italy and China are known for countries with the most World Heritage Sites in the world. So these two countries have in an amount of 55 each of the World Heritage Sites globally. So they basically cover a very significant portions of heritage sites in the world. So let's speak of natural sites. So take for example, a natural site could be the Grand Canyon in the United States. The United States Grand Canyon is a very beautiful place to be, to visit, take pictures, and even when you witness movies and there are scenes from the Grand Canyon, is an exciting sight to see. Then we have the Amazon forest, another very interesting World Heritage Site, the Amazon forest. Then we have the Amazon forest is located somewhere in South America. It is a large forest. I think it runs through 2 to 3 countries, if I'm not mistaken, but it's in South America. Then we have the Great Barrier Reef in Australia, another beautiful World Cultural Heritage Site to see. And then Mount Kilimanjaro, like I said, in Tanzania, Africa, the highest peak globally. There are some debates. There are other mountains that may be higher than it or they are in similar range. But for now, we consider Mount Kilimanjaro to be the highest. So these are cultural sites that we are referring to that are protected under the UNESCO Treaty, and they are specifically selected under the World Heritage List. Then we move to the fourth domain. So the fourth domain covers underwater cultural heritage. And this was done through a convention in 2001. So underwater cultural heritage, all artifacts that can be found on an underwater level in a sea, river, or whatsoever they might be located. So we're talking about shipwrecks within the Atlantic Ocean. And a typical example of that could be the Titanic. Those of us that have watched and witnessed the Titanic movie, the love story between Rose and Jack, and all those very talented actors. Up to today's date, the Titanic is one of my favorite movies, and it falls within the first 5 favorite movies that I've witnessed. So from the beginning of the movie, what you witness, the underwater wrecks, all these artifacts, these objects that were in the shipwrecks, falls on the underwater cultural heritage, which was made available or made known in 2001. So without, like I said, shipwrecks, objects in shipwrecks, man-made objects are well also man-made objects. We're talking about planes or whatsoever objects or boats that have fallen in the ocean or in the river. So you have a very huge plane, maybe, or logistic plane that will carry maybe, I don't know what, containers or carrying vehicles, and it fell into the ocean, and people can go there down the ocean and see all these objects within that plane. So it will also fall on underwater cultural heritage. So these are all sites or areas that people can go to visit. Yeah, there were, I think, a story last year. Yes, sometime last year, 2023. I don't know, some a group of people went underwater to see the Titanic, and some unfortunate or tragic situation took place. I think someone died in the incident, and it was all on the news last year. So these are cultural sites or shipwreckage could be considered as an underwater cultural heritage, and people often go to visit, spend vacation to these areas, whether natural site or cultural site. So we say shipwrecks, objects in shipwrecks, man-made objects like planes that are falling into the ocean. Then the last but not the least domain is intangible heritage regime, which is the regime that directly is linked to intellectual property protection. So this intangible heritage regime was done in 2003 under the guardians and supervision of UNESCO, and it covers traditional craftsmanship, social rituals, the foods, the different cultural foods. We have the delicacy, my native Liberia and my native Cape Mount. We have the cassava leaf or the basajama lofa. We have tabagi or tabasoye, bon kante, pepper soup with red oil. Then we have other delicacies that within Liberia. We have the favorite jollof rice in the world. I know my Nigerians and Ghanaians friends will want to debate me about that, but it's undebatable. The Liberian jollof is the best jollof in the world, and we can put it to test 10 times. Liberia will come top. Then we have dances and songs. So these are intangible cultural heritage, and they fall under the intangible cultural heritage regime of 2003. Cultural landscapes. So let me just conclude with the fifth domain, the last domain that has to do with intangible heritage regime of 2003 that covers traditional craftsmanship. We're talking about arts and crafts, all the cultural stuff, the marks, all these products that are made. And we're talking about social rituals. You know our traditional people, all the social rituals they are engaged in. We have the Sunday Sende, and the Poro societies of Liberia. These are all social cultural rituals that they engage in. Then we have the type of food, like I spoke of the Liberian jollof, the best in the world. And we talk about dances and songs. We have our specific and particular cultural dances and songs. And in Liberia, we have the culture troops. We have the culture troops. We have the traditional council, and we have cultural ambassador that is the representation of Liberia domestically and internationally, ensuring the promotion, the advancement of our culture, the promotion of our culture domestically, internationally, and helping to integrate the society into cultural activities, promoting the Liberian culture. And this applies to all other countries. I'm specifically highlighting like the Liberia case because I'm a Liberian and I'm knowledgeable of the issues relating to culture, intangible cultural heritage within my country. So these are the 5 domains that we cover basically, and these are the 5 domains. So an overview of the 5 domains I would like to highlight here is the first domain talks about the protecting heritage in wartime, and was done in 1954, the Hague Convention. The second domain has to do with movable heritage and was done in 1970 and protects cultural objects. The third domain talks about World Heritage Convention of 1972 and basically speaks to cultural and natural sites, talking about the 121 sites on the World Heritage List. Number 4 is the Underwater Cultural Heritage of 2001, talking about shipwrecks and objects that honor the ocean. Then the last domain talks about Intangible Heritage Regime of 2003 that is related and linked to intellectual property protection because it deals with arts and crafts. Arts and crafts, traditional craftsmanship, social rituals, food, dances, and songs. So these are all, we're talking about dances, we're talking about songs. So these are all intangible cultural heritage that are related and is covered under intellectual property protection. So I know when I place the notification that we're going to be discussing the topic, sometimes people can be triggered, but what does cultural heritage has to do with intellectual property protection? So this is the link, this is the connection. It's connected to intangible heritage regime that just deals with basically traditional culture and some natural issues. So looking at ongoing discussions right now, be it at the international level on the United Nations Educational, Scientific, as well as Cultural Organization, UNESCO, or regionally and domestically. These are ongoing discussions that some of these subjects and topics that may be covered under one of the 5 domains. There are discussions that they should be placed on a separate treatise for conclusive or holistic protection. There are other issues might fall under them, so they need to have a separate protection or separate convention. And these subjects are cultural landscapes, the regime of archives, our archives, whether high archive or soft archive. How can we have a separate regime that archive can be protected on them? And the UNESCO also have the Memory of the World. There's a program for that, and that basically falls on archive. So giving the essence and the pivotal nature of this archive, there are some discussion there should be separate regime for archive, for languages, and for cultural landscapes. So these are the ongoing discussions globally, internationally, locally, as well as domestically. These are some of the discussions that have been held. So moving forward, we want to understand the question we want to understand before concluding this first segment, because we are obviously going to have a second segment. We will not be able to cover all the materials today, so we'll have a second segment of the IP and intangible cultural heritage episode. So the question then that comes to mind now, given all that we have explained, how is cultural heritage regulated? How can we regulate cultural heritage? So heritage can be defined both as cultural or natural. That's the first thing we need to establish before moving into the definition of what cultural heritage is. So heritage can be defined as cultural, and it can be defined as what? Natural. However, there's a noticeable bias for cultural heritage as opposed to natural heritage, and this is because of intergenerational transfer of culture. So we know that there exists that cultural heritage can exist, that heritage can exist through cultural means or natural means. However, there are noticeable bias for cultural heritage. We always are attracted as individuals, as a people, as a nation and community. We're attracted to the cultural uh, tidings, the cultural trappings of our community, irrespective of your ethnicity, be it Vai, Baso, Mandingo, Pele, whatsoever ethnicity you are from, the culture, the tradition of that ethnicity, you have always attracted to it. So you have a specific bias to cultural heritage as opposed to natural heritage. And, and natural heritage in this vein could be within that identical community. There are lakes, there are waterfalls, there are specific mountains, and these are the natural heritage for that community. But people within that community will tend to have a specific link, bias, preference for cultural heritage as opposed to natural heritage. And the basis for this bias is that because Cultural heritage can be used for the transfer of cultures and traditional intergenerationally. So your children, your grandchildren will want to transfer your culture, maybe as a Bassa person, as a Vai person, as a Kwele person. You want to transfer your traditions and your cultures to your children and grandchildren so that the next generation will inherit that and will continue to further that. So your priority will not be about the giving preference to the lake, giving presence to the Patakwi waterfall, giving presence to the Nimad mountain, giving presence to all the natural heritage, but your preference will be placed on the direct influence your tradition and culture can have on your next generation. So that is where this bias lies. The intergenerational transfer of culture and tradition gives cultural heritage preference over natural heritage. But however, the natural heritage have a value to national identity. This is where the the priority or the importance and significance of natural heritage comes. Take for example, the Mount Kilimanjaro, located in Tanzania, gives Tanzania a national identity as the country where the mountain with the highest peak in the world is found. So that is a national identity. That alone, when tourists are going to visit Tanzania, or when discussions are being held on where the best, the highest mountain in the world to visit, tourists are attracted to Tanzania for Mount Kilimanjaro. So, because of that natural heritage of Mount Kilimanjaro, Tanzania national identity can be on the spotlight. So that is the significance of natural heritage to a community or nation or people. The natural heritage will be a national identity for a given community or nation. Where the Patakwi waterfall is located, when people troop from Monrovia or people on visit from in December and they are trooping to Patakwi waterfall, Bomi County or that specific locality where the waterfall, the Patakwi waterfall is located, if it gives a national, let's say, a county that identity, a community that identity, or the nation that identity. So, like I said, Tanzania has the Mount Kilimanjaro mountain. The United States has the Grand Canyon. Liberia has the largest green forest. So these are natural heritage that give significance to a nation's national identity. And this is where the significance of natural cultural heritage comes in. So appreciating heritage for the purposes of legal protection. How can we appreciate? How can that be done? How can we extract or give back appreciation for cultural heritage on the existing purposes for legal protection? So first we need to highlight the differences between outstanding value or we have to first highlight the significance and differences between outstanding value, meaning how magnificent the Kilimanjaro mountain looks, how tall, how high the peak is, what are the features there? Is it rocky? Is it greeny? Is it sandy? So the outstanding value, if you're doing a comparative analysis between Mount Kilimanjaro in Tanzania and Mount Nimba in Liberia, obviously, are you going to give appreciation on the basis that Mount Kilimanjaro is a bigger mountain, it have a higher peak to climb as opposed to Mount Nimba? How is the value of a specific cultural or natural heritage derived? How is appreciation even given back? Is this on the basis of the magnificent nature, uh, how mind blowing looks, or being a representative of a specific community within Nimba County or a specific county in general, Nimba, or a specific country, Liberia? How is the appreciation uh, given in the purpose of categorizing these cultural or natural heritage? So, appreciating heritage for the purpose of legal protection requires that we need to highlight the differences of outstanding value or the community value. Is it because of the outstanding value that Mount Kilimanjaro is significantly attractive to tourists, is significantly higher in peak, and may be significantly bigger or larger in length and width as opposed to Mount Nimba? So we should give more outstanding value to Mount Kilimanjaro as opposed to Mount Nimba. So this is the essence. And so there are two arguments. One argument is based on the organization you are coming from or the nation you're coming from. One argument say it should be the significance or the magnificence of the natural heritage. And the other argument say it should be a representative of the community. It doesn't matter how whether Mount Kilimanjaro is the highest in peak as opposed to Mount Nimba. It doesn't matter if Mount Kilimanjaro is well known, is more popular as opposed to Mount Nimba in Liberia. It doesn't matter if Mount Kilimanjaro in Tanzania has a larger length in size and width and peak as opposed to Mount Nimba in Liberia. What matters is the representation of the community where Mount Nimba is located. The representation of Mount Nimba in Nimba County. The representation of Mount Nimba in Liberia, giving Liberia a national identity. So these are the two arguments that uh, is based on how appreciation is given to cultural or natural heritage. So heritage regime operates in international law differently than in practice among these 5 domains. So all these 5 domains that we listed from protecting the Convention for Protecting Cultural Heritage during wartime, uh, the sites, the natural sites or the mixed sites, uh, cultural heritage for wreckage, all these five domains. When heritage regimes operate in international law, they operate differently in practice for all these regimes. So law heritage law or heritage regimes and policy are inclusive to other ideas. So that's why intellectual property is linked to Intangible Cultural Heritage Regime of 2003 because the heritage laws and regimes incorporates other ideas. So for example, cultural heritage that is linked to intellectual property can also be associated with human rights, can also be associated with migration, can be associated with economic integration regimes, for example, the European Union and the African Union. So, uh, heritage laws and regime are mutually inclusive to other ideas, to other existing policies and laws that deals with human rights protection, migration, economic integration, as well as other uh, existing laws and regulations. So this is what I wanted to highlight for the moment with intellectual property and intangible cultural heritage. So we will bring this episode to an end. We have another episode, maybe two more episodes or one more next week. Saturday, we are going to have the next episode on intellectual property and intangible cultural heritage to dig deeper into the relationship between the two regime, the two mutually inclusive regime of intellectual property as well as heritage law. So thank you for following whatever you are following us from. Have a wonderful weekend. I'm your IP and trade guy, Tom Tomika. Thank you for following us on the Intellectual Property and Trade Nexus podcast. We come to you every week on a Saturdays, and we will always be here to provide the necessary information for intellectual property, patent protection, copyright protection, trademark protection, geographical indications that is linked to intellectual property and is linked to intangible cultural heritage. But in our following uh, episode, we are going to dig deeper and dive deeper into intangible cultural heritage and how they are useful and can be protected on an IP law. So thank you. Have a wonderful weekend. We are looking forward to seeing you next week. Thank you for having us. Bye. Bye, guys. Close it. Yeah. See you next week, Saturday, for the second episode on IP, intellectual property, and intangible cultural heritage.